welcome everyone. Thanks for coming. It's a pleasure having you all here. Come to our White Noise Settler Law Justice talks at the Indigenous Law and Justice Hub. We try and look at how the white noise of settler justice continues to impact Indigenous people. So again, we're glad that you could make it. Just want to acknowledge that we're also on Wurundjeri land, and I want to acknowledge their elders past, present and emerging. I just want to acknowledge that special guests, officials from the Victorian Treaty Process over here, and others that have joined us and our regulars. Really want to appreciate your support and hope you continue to do that. As you know, in Australia, in times of change, and we're hoping that we continue to support one another to have some changes that we all want to live in a country that respects our First Nations people. As you all know, or some of you know, my name is Eddie Cubillo. I'm a Larrakia, Wajigan and Central Islander man from the Northern Territory. I'm the director of the Indigenous Law and Justice Hub here at Melbourne Law School. It's been a few years I've been here. We're continuously trying to develop the curriculum and also, just overall cultural changes within the law school. And so I'm pleased that we're joined tonight by Professor Val Napoleon, who is someone who's done a whole heap in this space. And I was saying to her just before that, I'm jealous of where they've gone and where they're about to go. And I said, I don't know if I'll see it in my lifetime. And she said, yes, I will. And so I'm going to hold you to that, Val. So I'll just give some rundown on Professor Napoleon. He's the Law Foundation Chair of Indigenous Justice and Governance, and he's based at the University of Victoria in British Columbia. I had the fortune of going there recently, and I was just saying the ferry ride to Victoria is just amazing and really soothes you while you get there. And no matter what happens to you when you get to Victoria, you'd be so relaxed. It's not a problem. She's from Northeast British Columbia, Treaty 8, and a member of the, pull me up if I say it wrong, Saulteaux First Nation. She's also adopted a member of the Gitnyao Gitsin House of Luxon, Canada Frog Clan. Professor Napoleon works on Indigenous legal theories, pedagogies, including feminism, citizenship, self-determination, and self-governance. She leads the joint JD and Indigenous Law degree program and established the Indigenous Law Research Unit with a number of partnerships. A friend of mine from the Gitsan people said I could say Professor Napoleon was invited into the Wilps Luxon via the ancient principle of Tisumul Gut. He told me how to pronounce it, Simul Gut, and has worked extensively with the Gitsan and others to codify some laws and continues to advance traditional law through her works as the director of UVIC's programs. Soon they'll be a core part of establishing the National Centre of Indigenous Laws. Can we welcome Professor Napoleon, please? It was fortunate that I know Neil and his family, and they speak really highly of you. And as you know, Neil was really respected up in British Columbia, and he's sorely missed from those of us who know him. So I just go to the questions. And as always, the first question is from this series is, who are you? Who is your mob people? And what are the values which drive you in this space?
That's such a good starting point. So as you said, I'm from Saulteaux First Nation, and I'm Cree, and I have my Gitxsan name because I'm adopted in. My Gitxsan name is Gyex Gun, and I belong to one of the matrilineal kinship units that are part of the Gitxsan. And so I'm a grandmother. I have one of my grandsons here to keep me on track. This is Elijah, who I really appreciate has traveled with me on this journey.
Yeah, thanks, Elijah. Sorry, I forgot to mention you, but you for coming. So in preparing for this, I was struck that both of us came to law later in life, after careers in Indigenous peoples advocacy, and that we both talk about decisions about coming to law relating to our roles as parents, and in our other case, we're both grandparents as well. You said in an interview, a law degree is really good driver's license in the world, but law schools can also be unfriendly places for Indigenous people. What drew you to law, and what was your experience in legal education?
Yeah, so when my daughter became pregnant, I wanted to be able to say something wise to the new grandbaby. I wanted to say, if you want to do something, you're the one that's got to go and do it. And I was sitting there thinking, but I haven't done it. So, because I had applied for law school as a young woman and I didn't go, life happened. And so I went. But the other reason is that what I saw is that women my age, and as we aged, we disappeared. Or we, we're in other roles and so on. And I wanted to keep doing the kind of work that I was doing. I was an advocate. I was, doing research. I was working on all kinds of amazing things. And so I wanted to keep doing that kind of thing. And so a law degree enabled me to do that. And one of the things that I've said to many grandmothers is that law school is good for grandmas, and grandmas are good for law schools. So anybody who has the slightest little curiosity about taking it on, go for it. There are hardships, for sure. I don't want to make light of the fact that law school can be a hard place for all kinds of reasons, and but it's also a place where other things can be imagined and other challenges can be taken on. So all of that together was a good thing.
Thank you, Val. It seems direct political action served as a training ground for you, including your involvement in organising around the historic land rights case in Canada, the Delgamuukw case.
Yeah.
What were some of your lessons and memories from that time? What wisdom from that time do you carry with you now?
Well, I hope I carry some wisdom.
Yeah.
So Delgamuukw was an extraordinary, powerful experience on so many levels. Every community was engaged, like families and leaders and young people, and we had visitors from around the world. There was, extraordinary connections with the rest of the world, and it was an opportunity to say, for the Wet'suwet'en people and for the Gitxsan people, to say to the world, this is who we are, this is how we're lawful to our laws, this is how we own land, this is how we govern ourselves and how we manage ourselves, how we solve problems. So all of that work and all of those conversations went on for years. And so I was, at that point, I didn't have a law degree, but I worked with education and I worked with employment and a whole lot of other things. And so what we had to do, the challenges that we were given, was to take the work we were doing and make sure that it tied in with Delgamuukw, so that every aspect of our work, so whether it was developing adult training programs, we made sure that it was territorial management, so that or fisheries technicians, or whatever it is, child abuse prevention, everything that we did, we made sure it reflected the kinds of things that Neil talked about, that other leaders talked about, and we provided a way for everyday people, kids and mothers and everybody else, to be a part of that bigger picture. So that was the power of it. And I feel so lucky that I got to be a part of that.
Can I say, like, in Australia at the time, we were having huge native title cases, say like the WIC, and then the 10-point plan, and it was a real attack on Indigenous rights. And at that time, I was fortunate enough, as I said to you, I was up in Hazelton, and I got introduced to this old man, and they said, "Oh, this is Earl." I said, "Oh, how you going, Earl?" And then I realised that it was Dalgamuk, right? Yeah. And for me, that was just so exciting, right, to meet this guy that was the main person for native title, and was able to sit there and converse with him. But also Neil mapped a lot of the country for the case, right? And just to hear the stories, and it really, you know, sort of pushed home for me that here's Indigenous people really fighting for what they believed in and their rights. And in Australia, we were at a time on the cusp of huge racist policies attacking our basic rights that we've won already in the High Court. And it was just something like really urged me on to continue to continue on with law. And so that, for me, that's the power of what First Nations people do all around the world, that we, it's a small world that we can bump into someone that does that right on the other side of the country. And it really inspires myself and others that what you do and others do gives us hope that we could possibly make some changes in not only in the country, but in places like here. So I just want to say thank you. And again, it was so important for me to meet someone like Earl at the time. So I just want to get onto the Law Research Unit. You run the Indigenous Law Research Unit at the University of Victoria. The unit is dedicated to revitalising Indigenous laws and works partnering with Indigenous communities, seeking to re-articulate their laws to address the challenges they face today, and focusing on Indigenous law differentiates your centre. It goes beyond the mission of other university centres working in relation to Indigenous justice. What is your vision for this work? And could you share a little bit about lessons from developing this work and your methodology?
Absolutely. So the Indigenous Law Research Unit, we imagined this as a way of working in 2011. And one of the original ideas for that, I read a paper, and it was by a couple of professors who were looking at Jewish law. And so what they did is they set up a way so that people from their different communities could ask questions of Jewish law. And they would support them, and they would help them with research, and so on. And so it didn't start from the basis that the only law in the world is state law, which I already knew wasn't true, because we had Gixan law and Wet'suwet'en law and everything else, and Cree law. So that idea of providing a way for communities to ask questions of their own legal orders, that was the original impetus. And so the research unit, we work by invitation. So a community, it could be any Tsilhqot'in or any other number of communities, and they'll say, we want to work on governance, or we want to work on lands, or we want to work on water, whatever. So we raise the money. We're not funded by the law school or the university, where we have a measure of independence, although we're housed within the university. And we work with communities for, each project is about 2 years. And what we do, I mean, I'll show you up here a little bit, or not.
Yeah, point over to that thing over there.
Okay. When it works, it's like magic, and when it doesn't, it's just, yeah. So, thank you. So I just need the PowerPoint. Oh, that won't do it either. Sounds like a depth charger, right?
Hey.
All right, so,
I'll sit here just in case.
all right, so that should do it. Okay. This is not working. Okay. So this is our methodology. Sorry about the, it's a bit overwhelming there. When communities ask us to work with them on areas of law, we first of all, we have a 3-day workshop. We teach our methodologies for local people. We spend a lot of time talking about what is law and what isn't it. We work critically with those ideas. We ask what makes law law? Who should have a say in what law is? What's the work that law should do? Who's excluded? Like all of those different kinds of questions about how is it that we manage ourselves as lawful people? Like what makes us that? And so we spend time talking about those questions, and then we gather all of the available written materials, published materials, and the stories, the oral histories, and so on, and we analyze those, and we create a synthesis. And then there's a whole iterative process that goes on, what we call a kitchen table verification process, where all of the analysis and synthesis and the work that's done is checked with people, everybody who cares about it. And so, the methodology that we've created enables us to have that kind of in-depth engagement with Indigenous legal questions. And what the synthesis then sets out is who are the authoritative decision makers, what are the substantive and procedural rights, what are the obligations. And it's based on the idea that the oral histories and the narratives and the stories, they're forms of precedent. They contain information that's necessary for future recall. And so our minds work better with stories. They don't work, none of our minds work very well with lists. And so if we think about case law, and we think about reading cases, they're stories, a particular kind of story told in a particular way. And so, and we draw on them. So it's a way of the previous generation talking to the next generation, and there are legal resources that can be drawn upon to solve problems, which is the work of law. So there's a whole methodology that's a part of that. There are different applications, of course, that communities decide to what they want the work they want the law to do. And then we spend time talking about where does law come from. We don't have big libraries, so what are the different sources of law? And we draw on John Burroughs' work here to have these conversations, and we engage in these. What does it mean that laws are founded on how we understand the sacred? What does it mean that law is one of the sources or authorities of law is deliberation? What does it mean to reason through and solve problems? So that's what part of what we do with the research unit. That's part of the work. And we've been working across the country on child welfare, governance. I mentioned water and lands, but we produce reports, law reports that the communities own. And with their permission, we share those reports. And we also teach with them, again, with their permission. So it's a very intense, iterative kind of process. I want to say, though, that the Indigenous Law Research Unit was step one. It's really, really important that we started that because it enabled us to imagine the next thing, which is our Indigenous Law degree program, which we launched in 2018. Students get 2 law degrees, an Indigenous law degree and a Canadian law degree. I teach Gitxsan land and property law with Niels Book, and we have Cree constitutional law alongside Canadian constitutional law and so on. So we have different legal traditions and different subject areas that comprise the Indigenous law degree. And so that's step 2. Step 3 has been mentioned, which is the National Center for Indigenous Laws. We're just about finished that construction. We've doubled the size of our law school to build this national center. And it's where we want to have critical conversations about law. So questions about citizenship, questions about gender, questions about power, like whatever it is about legal change, like all of these kinds of things that are really, really important for the health of any legal order and the health of a citizenry. Those are the conversations that we want to have. So that's step number 3, and that's going to be opened in March. February if we're lucky. The 4th one, I was just saying, has just been started, which is we're looking at rebuilding 5 legal orders, over entire legal orders, based on what we've learned over 5 years in different places in Canada. So that's the current project that I'm working on. So the Indigenous Law Research Unit was really an important launching pad for all the rest of it.
Well, I mean, again, yeah, I hope I'm around to see that in Australia, but we've got some professors here, so hopefully we can get them to help us get it there. So legal pluralism and Indigenous law. In 2019, you wrote a bold piece addressing a central area of concern for Indigenous people working with Indigenous law today, titled, "Did I Break It?" You speak about the practices of recording and writing about Indigenous customary law from traditional traditions, oral traditions, and common concern in community, that this translation or form and opening up of Indigenous law to those who don't understand, respect it, may lead to harmful outcomes. You consider law needs an organised and accessible public memory. Could you please share a little bit about how you would have grappled with these questions?
Yeah. So one of the things that we encountered in Canada, and I've seen it elsewhere too in the world, is when we talk about Indigenous law, and I see it with students that come into our program, there's a lot of fear. Like, people want to do the right thing. People want to learn. They want to they want to be able to work with their own laws, or they want to be good allies, or they want to, there's many dreams. And so, but sometimes there's a form of paralysis that because people are afraid, they don't want to be called racist, they don't want to be called make a problem. And so what I tell students over and over again is like the most respectful thing you can do is to ask hard questions of Indigenous law, as you should with any law, right? You have law has to do the hard work of problems. So what are concepts of fairness and inclusion and equality, and what are the different legal principles by which we reason through the complexities of life? So students need to ask those kinds of hard questions. And I also tell them they're not important enough to break it. Like, seriously, right? Like they're working with Gitxsan oral histories, the Adalak. So all of Gitxsan law is going on in Gitxsan territories. People are holding feasts, they're raising poles, they're protecting their territories, they're engaging with life as Gitxsan people. They're Gitxsan today, not as they were 10,000 years ago. And so, you know, our discussions about the oral histories or the narratives or the forms of oral histories or whatever we're talking about, like, that isn't going to hurt. And here's the big lesson. You asked, one of the questions you had was, you know, what have you learned? That was the big lesson, is that if we if we make sure that in our communities, that people have a healthy legal order and healthy engagements with it, that we have a legal interiority, that we have healthy legal worlds, which is what I'm looking at with the rebuilding of the 5 legal orders. If we can imagine that our laws are operational and functional and doing the work that law can do, then if students write an essay or write an exam in which they don't quite get it right, it's okay, right? Because what's going to correct it is going to be all of that density of Indigenous law that's going on in the world, and that's what we need to build. So, and we all make mistakes, right? So that has to be encouraged too, because we have to get over those fears, and that's what the paper was about, was, you know, and I
Is the fear directed at non-First Nations people, or is it?
You know, we have...
Australia, we struggle with accepting Indigenous people. We're here. We still, despite Terra Nullius being no longer accepted, it's in our deep psyche, and we're unable to get past that, to accept that, like you just said, First Nation people out on community and elsewhere are continually doing what they've always done until someone finds gold or something on their country. And we've had so much interference, say like for native title in this country, now you have to have continuous connection to country, and we don't take into account that some were dragged off screaming, and that's how we seem to, in these institutions, we continue to uphold that, those beliefs. So it's how do we get past that so that we can get our professors and that accepting that we need to have critical discussion about the legality of the legal system in this country. No one's expecting them to get on their boats and go home, but how do we have that discussion so that we can finally get past the non-acceptance that the laws in this country need to accept it?
Yeah, I think that conversations will change. Like, we'll make conversations change because we change the reality. You know, the world changes through intentionality, and we need bigger imaginations for what the future is going to look like. So what are we going to put in that future? Like, what are the concepts and the principles by which we're going to create that future? So there's so much in what you've just said. So on the one hand, yes, there's the resistances and the expression of those resistances through state laws sometimes, or through third-party interests and so on. So that is part of, you know, the capitalist and imperialist world that we live in. So that's part of it. The other parts of it are when Indigenous peoples, our students or others, don't feel like they know enough about their own laws. And here's the thing. We have to cut Indigenous people some slack. Like, no non-Indigenous Canadian knows all of Canadian law. Like, that is, but somehow we expect Indigenous peoples to know all of our laws. And so it creates a lot of insecurity, and then fear, like to do the wrong thing, or fear to ask the hard questions or whatever. So that's an aspect of it as well. So there's different parts of that require us to do some homework, I think, in how we teach.
Yeah, I don't want to just be negative. I mean, we got the Treaty Assembly President tonight who showed a lot of leadership, and I just noticed the chair of the Treaty Authority snuck in, Mr. Joda Clark, and that in itself is legal pluralism at its best at the moment in this country, where we've sat down and worked with government to develop an umpire to be independent of everyone to make decisions about treaties. So I think there's possibility, but it really needs some real big changes to, as you said, people not to be scared and that the sun will come up the next day.
We also, I think, like we spend a lot of time doing judicial education. We spend a lot of time educating not just our legal practitioners, but those elsewhere. It's work that has to go on at every single level. It's not something that can be, there's not one thing that's going to make the big differences. It's going to be the combined work of all of us. Yeah.
Yep. At this time when negotiations of treaty are commencing in Victoria through a process grounded in local law and cultural authority, I want to return to reflections from your 2012 paper, Thinking About Indigenous Legal Orders, where you say we must be critical and rigorous about this. There is no room for romantic notions of idealism. Romanticising will not enable us to govern ourselves as related to others on the power of our own ability to govern ourselves. We must apply the same critical thoughts to our Indigenous legal orders and laws as we do to Western law. How do you see this romanticising about Indigenous law operating in Indigenous and non-Indigenous communities in that context?
So one way it manifests is to think that all you have to do with Indigenous law is just to say what it is and to declare the outcome of it. So that Indigenous law is about stewardship, Indigenous law is about respect for the land, Indigenous law is this or that. And what happens is that you've foreshortened the intellectual processes that people have to work through in order to actually make a legal determination. And so that law by declaration, without that inclusion of all that is human, as well as considering the world beyond all that is human, like all of the ways that we need to be a part of meaningful decision making, that gets erased if it's foreshortened. If you just say it stands for this, it stands for that. I mean, for a few reasons, law changes, and the legal principles of, with some of the community partners that we're working with, their talk about law has to change. Law has to live, and if it's going to solve problems of this generation, we draw on the resources of the past generation. But if we try and understand Indigenous peoples as today as if we were 10,000 years ago or longer, then what are we? We're erasing a whole lot of experience, and how is that helpful? So that's part of what I mean by romanticizing. And I think that there's a lot of different ways of being Indigenous, and we need to make sure that there's room for all of that.
Yeah. I mean, we chatted earlier, and in this country at the moment, and I know in Canada there's huge issues around identity. Mm-hmm. And the biggest problem in Australia is the lack of understanding of what Indigenous identity is. Mm-hmm. And could you just give us a little bit on where you see identity in Canada at the moment? Yeah,
so I've been pushing back at the characterization of the issue as identity. And it's, from my perspective, it's an issue of citizenship. And citizenship is a matter of law, it's a matter of governance. And here's the thing, like why Indigenous law matters so much. You can't be a people without law, and you can't govern without law. So hence we have to make sure that we enable ourselves to be lawful, right? So citizenship, how do you become a citizen? We just finished a big project. This took 7 years with the Secwepemc peoples through the research unit. And what they said is we don't like the term citizen. What we would prefer instead is Quiselton, which basically is belonging. And so in order to do the work on this project, we sit and we articulate the questions that they want to ask of the narratives and the precedent and oral histories and so on. And the three questions that were articulated through that process, and this is, you know, lots and lots of different communities and lots of people. The three questions, one is, how do you become kin? The second is, when you are kin, what are your responsibilities? What are your obligations? And three, what happens, what are the legal responses if you are kin and you fail your obligations and you cause harm as a consequence? So those were the three questions that were asked of all the narratives, and the synthesis that was put together was based on those questions. And so there's a resource now for thinking about determining kin as people go forward. So that's a really different process and a healthier process than the federal government determining how much blood you require, or any other number of things that they've imagined and instituted over the years, which have caused all kinds of problems for people. So that's the Secwepemc determination of citizenship. For the Gitxsan, you're born into your mother's house. It's a matrilineal society. And there are laws for bringing in other people. There are citizenship processes for bringing in other people through marriage, or for population numbers, or for other, you know, economic purposes or whatever. So it's very clear, like, how this area of law is managed. And, you know, the Daneza, you know, we also, through the Daneza, we have different processes, and same with the Cree and other legal orders. So every society has citizenship laws.
Yep.
And those are the laws that we need to turn to when these questions when they arise. And we have to do the hard work of sorting that out. So, and what I've said, and I've published this more, and including in an op-ed recently, is it's only the business of Indigenous people. It's not the business of the Law Society or government or universities or anybody else getting on the bandwagon to determine who's Indigenous. That's a matter of Indigenous law. So what are those processes?
Yep. How you going? All right? You going okay?
I'm good.
Do you want some water? Okay.
I just keep blabbing.
Okay. Is it okay if we talk about Indigenous women and girls? So one of the most tragic harms of colonisation is the violence against women and children. There's a harrowing phase that has become so common in both our countries, missing and murdered Indigenous women and girls. The Australian Parliament will release a report on their inquiry on the subject. This is an important and difficult topic for us to discuss. So in Gitxsan Legal Personhood, Gendered, you wrote about Cindy Gladue, a citizen of Cree and Métis law and experience of court processes in the Gladue case. To quote you, in Canada and elsewhere in the world, there is a societal scale failure to ascribe political and legal meaning of the decision and action of Indigenous women and girls. This is the case both before and after their deaths. You later asked, against this distressing but real backdrop, what does agency mean for Indigenous women and girls? How and why does their agency matter? What are judges and judgments missing about the agency of Indigenous women?
So I think the concept of legal agency is central to all Indigenous legal orders in Canada. We were non-state legal orders, that is, authorities, and the law was distributed horizontally through horizontal or decentralized institutions. So people needed to be strong agents. Because you don't have a delegated group of people responsible for the law. You don't have centralized institutions that are responsible for all of the law. Instead, you have numerous people who have responsibilities and processes for that kind of decision making. So for women, lots of what's happened for women is that, with the missing and murdered Indigenous women and girls and trans and gender diverse, is that we're only seen as victims. We're not seen as women and gender diverse and trans and girls who are making the best possible decision in any circumstances that we find ourselves in. And so with, Cindy Gladue was a particularly horrifying murder, and her treatment as an object continued after her death in court. And so the question about, like, how is it that Indigenous women and girls and gender diverse and trans are disposable in Canadian society? How is it that we have a country where those are the conditions within which Indigenous vulnerable people have to try and survive? And so the question, pushing the question of agency was, I did that in a class because students seem to only be able to talk about Indigenous women and girls as if we're only victims. And so what I was saying is, like, can you, in your understanding here, can you understand Cindy Gladue as a citizen? She was a citizen of her people. Yes, she was all of these other things, but can we expand our understanding of her? And what happens in our understanding if we can do that, if we can challenge ourselves to do that? So that was part of what went on with that. And the other thing is that, lots of our oral histories have violence against women and vulnerable. And so there are lessons that we can draw from our own oral histories to deal with power and abuse of power and so on. Lots of the stories, and have resources that enable us to do that. And I'm just starting another project where we're bringing together Indigenous women, and that's what we're doing, is looking at what are the resources within our legal orders that we can start building, drawing on the resources to build concepts of justice, like justice shelters or legal shelters within our own laws. And so that's a current project.
You highlighted gendered violence experienced by Indigenous women and girls happen in a place of lawlessness, where Indigenous law has been undermined through distortion and Canadian law failing to protect people.
Yeah.
Could you unpack this for us?
Yeah.
And how does it actually happen?
So I think that it's helpful to think about the experiences of Indigenous women and girls and gender diverse and trans as being on a spectrum. And so at one end of the spectrum, we have the horrific violence that, we have had a national inquiry to look at, and reports have been written. We've had, I think, something like 30 different inquiries into the violence. So at one end of the spectrum, that's what we have. And at the other end of the spectrum, we have idealizations of Indigenous women. Like, we're the heart of the culture, we're whatever. But they're often, a lot of them are stereotypes. So it's the other end of sexism. And then all the way along, you have different decisions that have material consequences, whether it's housing or employment or whatever. Like, so if you think about that spectrum, that's, and think about the connections between those different realities, that's a part of it. But the other part of it is that when there's a lawlessness, when Indigenous law has been so undermined that people no longer have those resources through which to take care of one another, through which to act on our responsibilities for one another, when that is absent, when that's been trampled and taken away or whatever, we can look around the world at lawlessness, and you can look at the kind of violence that happens in those places. So we have lawlessness created by that absence, and then you have Canadian law, which fails to protect in those spaces. So part of the work, that the rebuilding of Indigenous law is to rebuild that lawfulness and rebuild that safety. When we look at, like across the country, we look at aspirations of Indigenous law, they include safety, they include fairness, they include equality, aspirations that we share. So those, that's the work that's necessary, is to restore that and that ability for our communities.
Thank you. Legal education. In 2015, the Canada Truth and Reconciliation Commission drew attention to the cultural capability of the legal profession, stating that the courtroom experience of survivors of residential schools was made worse by the fact that many lawyers do not have adequate cultural, historical, or psychological knowledge to deal with painful memories that the survivors were forced to reveal, and this lack of sensitivity resulted in many survivors not receiving appropriate legal services. The TRC made calls to action for Indigenous cultural capability being central to legal education, and we're hoping that the Europe Justice Commission will make similar recommendations here in Australia and in Victoria. Have you seen the law schools respond?
Yeah, law schools across the country have been doing different things. So one of the things that I'm really proud of is that the Truth and Reconciliation Commission report, recommendation number, TRC call to action number 50, was based on our work. It's based on the Indigenous Law Research Unit. And so what they called for was to rebuild institutions for Indigenous peoples, to restore laws, to rebuild laws. So what law schools have been doing is various things. There's some places where they have standalone courses, or they've had introduced curricula, which is mandatory for everyone in the first year, or they have different course offerings. But we don't have anything. There's not another law degree program right now, but people are making steps, and I think that there are a lot of good people that are trying to do that, like Jeff Hewitt, yeah. Who can't be here tonight, but he's been doing amazing things at Osgood. And John Burrows and others, so that the regular Osgood and Toronto and other places are actually running field schools, yeah. And they take the students out and work with Indigenous communities. So
sounds like a real good idea.
Yeah, it's fabulous. So there's different things like that happening.
Jeff's teaching at the LLM, so for those who are interested, he's really an awesome individual and knows a lot about the laws in Canada and particularly Indigenous stuff. Yeah, amazing guy. I just wanted to ask, coming to the end now, but I just wanted to ask you about your dual degree and what has been most unexpected benefits for you about this program, and what are your hopes for the program in the future?
Oh my goodness. It's still a little bit surreal to me that we actually have this degree. We actually did it. It's just like, wow.
Yeah, it's amazing.
So it's still small. Like, we only have 25 students a year that come in, but over 4 years, it's a 4-year program. So that's 100 more students in the law school in addition to the JD. It really makes a difference in terms of what are the kinds of conversations that we have in the law school, and We are working on co-teaching with non-Indigenous colleagues so that we can expand the capacity in our law school for, and we're also looking at, what we didn't want to do was to create two silos, Indigenous and non-Indigenous, and so, but we've kind of inadvertently done that anyway. So what we're looking at is what are courses that we can teach across for everybody, that will be inclusive for everybody. So one of them is going to be the methodology course. So this swirls and things up here, that can be a 3-day workshop, or it can be a 1-month course, or a course taught over a term. And so what we would do is like have all of the students in both cohorts take the legal methodology course, which means they have to work with oral histories, they have to look at community experiences. They have to develop enough of a context of understanding from different Indigenous societal perspectives that they can see the aspirations of law and the logics of law from different legal societies. So that's one possibility. The other possibility is to have both cohorts take Gitxsan land and property law alongside common law property, or Cree constitutional law, or so we're looking at different options right now.
Okay, last question, and we'll go to questions to the floor. Could you tell us a little bit about the work you do through your artwork in drawing the trickster, generally represented as a male raven, as a feminist social activist grandma?
So the trickster, so in Cree, we don't have gendered, the language isn't gendered. So I grew up being called he, him, because my mother, who only spoke Cree, would, call my brother she, or so, the whole her, she, him, that wasn't a part of how I grew up. So what's happened is that tricksters, which are an intellectual creation, which enable us to deal with contradictions and the bizarre, and which teach in many ways, sometimes lovingly, sometimes a slap upside the head. So they enable us to look at our own contradictions. They enable us to look at the bizarre. And so I created Kokum Raven. The raven is a trickster for many people. Kokum in our language is grandmother, so I'm Kokum Val. There's a raven here, and the ravens, we use them in workshops and in different places because they can be a jumping off point for a conversation. So this is about doorways, and so one of the ways to think about law is as a grid of intelligibility. So what does that grid of intelligibility enable you to see, and what's erased? And one of the ways that we can explore that is through images. This is one. There's a couple of others here that you can look at really quickly, if I could figure out how to do this. No, that's not going to work. No. Can I go back? Or I go to the next slide?
Yeah.
Okay. No, this one. No, the one before. Oh, you can't see her very well, but this is, she's riding an Indian motorcycle, as all grandmothers should. And I only just sold my motorcycle. So, this is an image that the conversation can go in many places, right? In terms, including gender roles, right? Including the name Indian, including all kinds of things. So they're good in that way. The other thing that's really good about images is that you have something to look at. So if your mind wanders, and also I was told one time, we think better if we have something to look at. So they're useful in many ways. So we can go to the next one. This one. Okay, so this is part of, you know, the moss in the far north, in the Yukon or in the Northwest Territories, at certain times of the year, it's brilliant. It's all colors. And so this is partly about the land, but it's also partly about the grandmothers and the people who are on the land, who are out there working, usually in a way that is unrecognized. And so, and there's also all different kinds of ways to love. And so this image is, you know, allows us to explore all different kinds of things. And so that's how I use the images. They just open up ways to talk, you know, that can be helpful.
All right, we finished the question now. Can we just give Professor Napoleon a big thank you? And again, it's amazing, and like I said, I just come back from Canada and had opportunity to speak to people, and hopefully one day we can do the same. And again, what you do and John and others do is really inspiring for Indigenous people working in this space. So really thank you. Okay. Got questions now? Any? Oh, that's good. We got a dinner. Oh.
Hi, thank you so much. I'm Andrew. I'm a Palawa man and working in the Treaty for Victoria space here, and so it's really great to have you here. And you being a lawyer who had to study just a regular JD, I'm really excited about what you've done there, and just wanting, like Eddie, wanting to see it occur here. And what do you think was the most significant hurdle, or probably like the biggest one to get through to get it achieved, or to get into the space, or sort of maybe the one to target for us in this space, wanting to see it happen?
One of the, part of what I think is really important is, you know, what I was saying earlier, that there's not going to be any one way to do this, that work at the local level, work in universities, work in Indigenous governance, in businesses, like everywhere, there has to be as many conversations and critical conversations as possible, and support for communities to do the work that's necessary. When we first started this work way back in the olden days, or like Elijah said to me one time, he said, you know, Grandma, you know, Kokum, in the olden days when your hair was brown, you know. So we don't have to argue that Indigenous peoples have law anymore, which was the argument that we had to make. So, and the research unit, part of the wisdom of the research unit in terms of what it does was that whatever misconceptions or resistance that people had to Indigenous law, we could say, look, here's a report, and you can read this, and it's cognizable, and it's clear, and it's how it's one way to look at things. And so we were able to take away some of that mystery or the, you know, just the resistance of people not knowing, and fear of the unknown, and push past that. So I think that the research unit enabled us to step up the conversations and say, okay, so yeah, this is, when people are saying, oh, that's impossible, there's too many different Indigenous peoples, like, how are you going to do it? Like people are so disorganized, or whatever it is that they're thinking. We can say, actually, we can, and we've been doing it now for 5 years or 10 years or 15 years or whatever. So it's work that's doable. And that's the big thing, like to get to that point where it's not that fear of the unknown.
Sorry, I'll hand this over in 1 second. Val, thank you so much. I feel like I have 1,000 questions. One of the things that we were talking about before, and that's been a theme for you tonight, is the sharing of knowledge in different places, and particularly Indigenous legal orders. And so I've been part of an exchange with Indigenous peoples between the US and Aotearoa in Australia talking about water law. And Adriana Nicolay, a Navajo Diné woman, framed it around, and this was what she said: our oppressors learn from each other, and so we should too. And so I just wondered if you could talk a little bit about how your work in starting to expand and increase the density of Indigenous laws, is that supporting the different nations from learning from each other as well across Canada as each makes progress in that space?
Yeah, I think that the more that's visible and possible, like enables the imagination of others. It enables people to extrapolate. So if they've done all that work on child welfare, then we ought to be able to do it here too. And what are the things that they had to do in order to do the work? It's really interesting. One of the the thinking and learning across legal orders takes as much work between Indigenous peoples as it does with the state, especially if you're coming from different places across Canada where there's a 400-year difference between the East Coast and Hazelton. Like, so the Frank Calder of the Calder decision remembers the first white fella he saw, like, so as a kid, right? So that it's recent history for, Western Canada and Northern Canada. So depending on where you are. So yeah, there's the more examples that can be provided and the more sharing of the hard lessons and the mistakes, like, so that, if we can discourage people if we make it look like we never made any mistakes in doing the work. And that's an important part of this. And so, yeah, there's so much amazing and valuable work that Indigenous scholars and leaders and everybody else are doing. There's lots more to do, absolutely lots more to do. And it's not always easy and it's not always fun, but it's pretty darn amazing.
Thank you so much, Professor. That was amazing. I want to ask a question that follows on from your response to Andrew's question around, that idea of being able to use a foundation of research and a foundation of, we can do this, it actually works, based on knowledge and research and empirical good things to dispel fear or concern. In Australia, it feels very much like we don't have any sort of cultural maturity or societal maturity that might be able to grapple with the moral panic about, there's a system of law for us and there's a system of law for them, and that's a huge part of the reason why the Voice to Parliament vote failed, was that sense of the unknowable dual system of law. And I wonder whether there's anything you can tell us about the sense of maturity and the sense of readiness of Canada as a society and as a body politic to engage with those issues on more than a mere superficial, knee-jerk, soundbite, tabloid headline basis. Because at the moment, that's the point where it feels like the Australian body politic sits in terms of discussing any sort of relationship with First Nations people, any sort of approach to treaty, any sort of approach to maturely bringing elements of First Nations law anywhere near a conversation about incorporation into what might be, into colonisers' law?
Yeah, thanks. One of the big hurdles, I think, is that narrow understandings of what law is. And so if you have people that understand law as simply being about authority and rules and telling other people what to do, that's a pretty impoverished view of what law is. And there's going to be resistance based on that understanding of. So, part of the reason we spend so much time talking with communities about what law is that, when we first started doing this work, people would say, oh, we don't have law. We have ways of doing things, and so on, but we don't have law. And part of what we realized is that people were thinking that what law was what looked like the state law, looked like the police, looked like their worst experiences with law. And so that was a problem. And so that's what we had to work with. And also it's helpful to find people's own words for law, like ayok or other words that in the language. So but I think that the conversations about what makes law a law, or what should it be, and how do we, that it's a human creation, those are conversations that every Canadian should have. Like around every non-Indigenous kitchen table should be at least some understanding of how the world works and how are people a part of that those bigger processes. So I think that's a piece of it. It's an important piece. Like if civil society and democracy don't have any meaning for people, they will lose it. And as I think Boaventure de Sousa Santos says, we're killing democracy democratically. Because, what is it that we're doing in the name of it if we've narrowed it down to something that doesn't have any promise for people. So the other thing is that I think, we've been fortunate, like with Delgamuukw and with other things, is that with litigation, with work on every front, no one can ignore Indigenous legal issues anymore. It's an impossibility. And so it has to be dealt with, and you have a choice of how you're going to deal with it. You can negotiate, you can talk, you can do whatever. And that's not to say that everything's wonderful. I don't want to give that impression. But just, I said at the beginning about what is it that we can imagine in the world, and the world being created. We live in worlds we imagine to exist. And intentionality is a huge part of that. So what is it that we imagine? And so the big project that I'm embarking on with rebuilding Indigenous legal orders is to encourage an imagination of abundance and promise instead of donors' limitations for the rebuilding work of Indigenous peoples. And there's obviously much more. I think that kind of legal imagination and that kind of intellectual life, it's really important to protect what we have, and I think that it's under a lot of stress in the world. And Indigenous peoples are not isolated from the stresses of everything that's created climate change and the climate crises.
So,
Hi, Val. Thank you so much. It's really incredibly exciting to be in the room and hear from you. You just mentioned litigation. I'm a practicing lawyer, and one of the things that people seem really keen on in social justice, particularly as strategic litigation. And just thinking about it in context of what you're talking about does feel a bit impoverished and narrow, especially after your last question. But I was just wondering whether you and the people, the Indigenous people that you work with, have any interest in strategic litigation as it's arising from the research that you're doing and the ideas that you're coming up with.
Absolutely. So with the research unit, we don't focus the research around a litigation end. But if people use it in that way, that's their call. People can do whatever they want with it. So what we've seen people doing is using the reports and so on to structure government-to-government negotiations, to create environmental assessment processes, to negotiate other kinds of agreements, or to use in various adjudicative processes. So there's once you have the information, a symmetrical conversation is possible. And like until Indigenous peoples are at that point, then we're always going to be seen in a deficit. Or what's going to happen is people will be forced into positions of just replicating state law. So what I've been encouraging litigators and government and everybody else to do is that if you have Indigenous law expectations of Indigenous peoples, then find a way for people to be supported so that they can do the work that's necessary to build a symmetrical relationship. And I think that changes the nature of what's litigated as well. Like, so again, you're not talking about Indigenous law as fact or evidence. You're talking about, here are Indigenous legal principles that can be used to reason through a response to this problem, right? So it's necessary to make those changes in all of the conversations that we can.
Can I ask a quick follow-up to that? Because I've heard Eddie talk before about sometimes there being challenges when it comes to people in practice deciding with maybe some community members or in a limited way on what could be beneficial to litigate, but then not being mindful of broader outcomes and what that might mean for other community. And it sounds like what you're saying, if you can establish those frameworks, it helps with agreement about what might be beneficial as well.
I'm not sure I heard everything you said, but what's really important in doing the rebuilding, the partnerships through ILRU and through the future work is not choosing sides within or leaders or whatever within Indigenous communities, but rather making sure that all the different perspectives are a part of whatever's going on, so that it is inclusionary, so it's not picking and choosing those issues. Stop moaning. I don't know if that answers your question. You've been so patient. Thank you.
Hello. I have a question regarding, so for context, I'm attached to University of Colombo and the Supreme Court of Sri Lanka. I just have a question as to what lessons we can apply in terms of Southeast Asia or South Asia in general regarding Indigenous law.
Yeah, thanks. One of the things that I'm realizing needs more thought and work is what happens when the state law is civil law or common law or some variations, because that really changes how people talk about law and understand it. So that is like civil laws or common law, like that conversation in terms of different parts of the world needs to be thought through. Because when we've done our workshops with folks from primarily civil law backgrounds, some of the work just doesn't translate. So that's why more thought is necessary. But what I've found is that it really, whatever questions people have about their own legal orders and whatever materials they're able to look at and they begin to ask questions of it systematically and critically, that there are ways to learn from people's own oral histories and stories and so on. And this is, not on point with what you've just said, but like, for instance, in Canada, we have some large religious communities like Hutterites or Mennonites or in different communities that where some members from those communities have started or been drawing on the methodology to challenge sexism in their communities, right? So because what it does is it opens up different ways of looking at issues and looking at, because in any human society, nothing is ever done the same way, right? So there's always variations. And so it just creates another way to expand the conversation. So I think that can be extended much further.
There's a lot of students here. Can we get one of you to ask a question as well? Drop in Slack, all right? You know who. Sorry, mate, go for it.
There are two laws operating in this country. There's a sovereign black law and a white law. The more aggressive law is the white law that has jurisdiction or believes they have jurisdiction. And as somebody mentioned down the front, that the referendum question, I think, frightened people thinking that Aboriginal law may be somehow recognised or would threaten the white law. But my question really is, what's the experience in Canada? Because I just come back from the Northern Territory, and the jails are, if not 100%, 98% full of Aboriginal children and youth and women, etc. And one of the problems, as far as I can see, is that the jurisdiction, the law, white law, is subject to being judged by your peers. Now, you imagine a situation if you're a young Aboriginal person breaking a window or stealing a Toyota in one of those, and this could be universal, then to be judged by their peers. It's not their peers. 99% of the time it's a white jury that convicts these kids. No understanding of the Aboriginal law that may apply, the customary law or the traditional law. Is there any method, even though we have a Koori court here that talks about sentencing options, it's the first step, but is there any other step in Canada and the First Nations or the domestic sovereign situations or the status Indians where they challenge this concept of white superiority and being judged by their peers?
So there's certainly been challenges to the whole jurors and juries, but I think, I think there's a couple of other steps that have to be taken. One is to look at, and we did this in 7 different legal orders across the country, where we looked at how do people in this legal order legitimately respond to harms and injuries. And what that enabled us to do is to look at what are considered harms, what are considered injuries, but also what are the legal processes and who are the legal actors that have to be a part of working with those who've caused harm and those who've been harmed. And so if you go to our website, there's a Cree example of a report. You can look at the work of Hadley Friedland, her book on the Wetago sets out the different principles regarding harms and injuries and the collective responsibility for dealing with people. Like so what I'm saying that the work in looking at crime has to be backed up, and so people, in Canada, there's been a range of different things. Some of which is, I think, probably pretty successful in dealing with, the courts and young people and so on. But there still needs to be that whole rebuilding of lawfulness that I was referring to earlier. We still have the highest incarceration rates, Indigenous peoples in Canada. Like one of the impetus of the rebuilding legal orders, like stepping up the work we're doing, is because the incarceration rates are remaining high, and Indigenous women and girls are still being murdered and going missing. And so we have to step up the work we're doing, because those are still the realities for us, as I understand that they are here. So I agree with you. There's absolute all kinds of stuff that needs to be done with the existing criminal justice system, but I also think that that the work of rebuilding Indigenous law is another whole area that needs as much time and energy.
All right. There's one last question there, and as a student too.
So two quite quick, maybe not very sexy, pragmatic questions. The first one is, you said it's about funding, and you said that the Indigenous Law Research Unit has independent funding, not funded by the law school or the university. I was wondering, is that philanthropic, and if you could speak a little bit more to how that works, and health and trust, etc. And the second one was, through your work with the university and universities across the country, did you encounter much reticence or difficulty in kind of justifying your activities, or did you find that people were largely receptive to your reports and your work? And how your colleagues sort of reacted, and how you navigated that space?
So at the institution I was formerly at before the University of Victoria, I had to argue all the time that Indigenous peoples had law. Okay, so that it's now changed, and there's more people, and that's where Hadley Friedland works, and so on. So, and they have the Wekotowin Law and Governance Lodge. So things have changed there. So when we, in Victoria, what we did is we just started doing the work. Like, so we're successful in obtaining money for a national project. And we just started doing the work. We held seminars, we trained students, we sent teams of people across the country, and we just started introducing ourselves as the Indigenous Law Research Unit, and after about a year, the law school gave us a sign. So that's, I think that's the best approach. Insofar as funding, we have foundations, of course, and then there's different research grants, and there's and some government, and so on. So it depends on what it is that we're raising money for. That comes from a mixed sources. So what we try and do is to have enough money so that when a community comes with a question and work that they want to do, that we're able to support that work. We have our staff, we're able to do it, I run a 2-year project, a fairly intensive 2-year project. Or we assist that community to raise the money. So there's a number of ways that we work. It does take time. And there are things I'd rather be doing. But right now, that's the way it is. So that's what we're doing. And I think the fact that we're a part of the law school, but not funded by the law school or the university, gives us a fair bit of independence that is that's healthy for us, and I think healthy for the institution as well.